litigious Donald Trump files motions all the time in all his cases. He loses almost all of them. He loses court cases. It doesn't matter. He just brings frivolous matter after frivolous matter, whether he's fighting, saying that the election was stolen. He lost almost every one, if not every one of those, all across the country. He files motion after motion after motion in all of his criminal cases, civil cases. He is the most litigious person and doesn't care that it's frivolous when he files these things, and he loses over and over and over again. But he does it because it's a delay tactic. It's his number one tactic of or his defense. So let's think about why would he want to delay a case, and then we're going to talk about the fact that there is one motion of all the motions he's ever made that we need to pay attention to, because it's the one non-frivolous motion, actually. I think he's going to lose it, but let's talk about it. And that's why I want to highlight it for everybody, that I know we always talk about how everything's a loser, everything's frivolous. This one is real, and it's something that we all have to think about and be prepared for and fight back on. So Donald Trump filed this notice of appeal and motion for stay in the DC Tanya Chutkan case, the Jan 6 case, right? The special counsel Jack Smith case. And what this means is when he made a motion to Tanya Chutkan saying that he had presidential immunity, and also saying that the case is barred on double jeopardy grounds because he was already indicted by the House and tried in the Senate and acquitted. And so therefore double jeopardy applies. So that's going to be also appealed, and both are constitutional issues, which is why he's allowed to appeal them midstream. And why would he do this? Why is delaying this his best friend, and why does this help him? And the reason is because if this case goes to trial, I think he's going to be convicted. I think it's a very strong case, and he could be incarcerated, frankly. And that's a big deal. And he doesn't really have a defense, I think, to January 6th and him trying to steal the election. The evidence is overwhelming. So why does he want to delay it so badly? The reason is because he thinks, and this is what he wants, this is his master plan, to delay it, have the election, win the election. And if he wins, he can appoint the Attorney General, the head of the Department of Justice. He can dismiss the cases against him. He can pardon himself and all his, all the co-defendants and unindicted co-conspirators. He can pardon all the people, the Jan 6 people who have already been convicted and are incarcerated. So this is a very big deal. I cannot understate for you, or overstate for you, I should say. I cannot overstate for you how important it is that this case go to trial and become adjudicated one way or another before the election. Because God forbid he wins, you will never see this case ever. Okay? So that's why these stakes are so high. And that's why this particular motion scares me, because it's somewhat real. Now, if you recall, what he said was that he has presidential immunity for any criminal act. He says while he was president, he was doing his job, and he should be immune from prosecution. Now, the law, no one's ever ruled on that before, whether there's absolute immunity for all criminal prosecution if you were president, especially if it was while you were president at the time that the conduct occurred, which he was, right? He was both president and candidate Trump at the time. And so he's saying, therefore, he should be immune. And he cites cases that say that. He says, and the other thing he says is that he also said that about civil cases against him, that he should be immune in any civil cases. And there was another case, it was called Blasingame, which had to do with the cops, the Capitol Police officers. Some of them were suing him for what happened on January 6th. And he cited presidential immunity there, that he was acting within his job description and therefore he can't be sued. And the DC Circuit, which is the appellate court, overseeing the case, ruled the same day that Judge Chutkan ruled on her presidential immunity, ruled that he was candidate Trump at the time, and therefore he is not immune civilly, and therefore that suit can proceed. Well, Judge Chutkan ruled very similarly, and basically said, look, it would be preposterous that you should be able to do whatever you want and just say, well, because I was president means I can't be prosecuted. Well, that's just not true. And she ruled against him in that regard. And so it's going to go to the DC Circuit. And I think Blassingame, though, is a pretty good indication of how they're going to rule, although the case specifically says we're not ruling on criminal, on what this applies to a criminal case, just civil. But the issue here isn't how they're going to rule, because I think it's pretty clear that Trump's going to lose and he's not going to have immunity, absolute immunity and from being prosecuted. The issue is whether it delays, right? Whether it delays the case because it has to be ruled upon, because it's a fundamental, it's a fundamental aspect of this case, right? So he says that basically in his notice of appeal and motion for a stay, he says, look, there should be an automatic stay of the district court, meaning Jack Smith's case in front of Judge Chutkan, and all the proceedings in the case pending a final resolution of this appeal. That the rulings on presidential immunity and double jeopardy need to happen before the case, the appeals have to finish before this case can proceed to trial. He says that this notice that we're talking about that he gave the Judge Chutkan and the parties, he says this notice deprives the court of jurisdiction. That's mandatory and automatic. Like I said, I think it's a delay tactic. And the other question, some colleagues of mine are talking about, an individual, a lawyer named Andrew Weissman, who's a really smart lawyer. He worked on, I think he was on the Mueller investigation. He's just a really smart person. He tweeted out that he thinks that the doctrine of latches apply, which means that that basically Trump strategically delayed making this motion, and he should have filed this months earlier. And the only reason he did it was to get a strategic advantage, because he waited until after discovery happened and he got all the discovery, and that's why he's making this now. And so therefore, because of that, and because he waited too long to make this fundamental question of whether he has presidential immunity and double jeopardy, that it should be denied because of this doctrine, the doctrine of latches. And, I hate to go against someone like Andrew Weissman, but I'm not entirely sure that I agree, just because, I think he waited until Judge Chutkan ruled, and now he's appealing her ruling, and he did it right after she ruled. And, he filed his motions in accordance with the motion practice, right, with the dates that Judge Chutkan set. So I don't see how it's really a delay, and I don't know that it would have been ripe if he appealed before he allowed her to rule. So anyhow, that's just my opinion. I do think it's a delay tactic, but I don't know that doctrine of latches will actually save us here. But Trump cites the Blassingame case, saying that it requires the court to stay all the proceedings in this matter pending appeal, including pretrial motions, pretrial defenses, SEPA, the jury, etc. But don't forget, Blassingame was a civil case, not a criminal case, so it doesn't really apply. And he says all the current deadlines should be held in abeyance, and Trump will not participate in the case any longer unless the court orders him to do so. And he cites another case, Coinbase, saying, that also stands for the proposition. But that was a case about whether or not the case has to go to trial or go to arbitration, that there's a clause, and it wasn't sure. And as a result, the trial had to pause or be stayed until they figured that out, because otherwise, it wouldn't make sense to have a trial only to be then told, no, you weren't supposed to have a trial. It's an arbitration. And so I don't think that applies either. And he also says the Supreme Court says that the stay would be mandatory and automatic because of these two cases that I just mentioned, Coinbase and Blassingame. But, so it's just unclear what they will do. And, he also says an appeal divests the court of jurisdiction, and therefore this case cannot go. He says, presidential immunity is immunity from suit, not just immunity from liability. And he cites Griggs, which is also a Supreme Court case. And that's another case that he says stands for the proposition that this has to be paused. Yeah, and he also says that he cites Blasingame again for what it says, Blasingame, but that's a civil case, so I just don't think it applies. But again, he strategically waited for Chutkan to decide the order to divest her of jurisdiction because he's appealing her ruling. He also says, as a matter of public policy and judicial resources and financial harm, reputational harm, et cetera, it should be stayed. I don't disagree with him. That being said, they better expedite it, and I'm sure they will. So I don't think it's going to work in the D.C. Circuit. It's the Supreme Court that worries me, because I don't know what they will do. So let's see, how this goes and what they do. Hopefully Jack Smith will file his request for an expedited briefing schedule and oral arguments fairly quickly so that we can get this going. And then hopefully it will not stay the trial, because this has to go quickly. And I think the DC Circuit will make it go quickly, because they just ruled upholding the gag order. They signaled, in that same case, right? They just upheld most of the gag order. They limited it slightly. But, they basically said in there a couple of times that, for example, this case, that, Mr. Trump filed an emergency appeal and a motion for stay order and request for an expedited appeal. And the next day, this court administratively stayed the gag order. And because of the approaching trial date, set a highly expedited schedule for the merits appeal. So that signals to me that they're going to do it again in this. They also say in that same decision a little further out, they say, in this case, the general election is almost a year away and will long post date the trial in this case. So as a result, I really do think they are going to make sure that Trump does not use this as a delay tactic while at the same time ruling on the merits of this very important thing. I mean, it does have to be ruled on ahead of time. So I think we'll be okay. I don't think it's going to derail the election. Of course, the caveat of the Supreme Court and what they might do. Judge Roberts, the chief judge, is the judge who sits over the DC Circuit. Hopefully he will just affirm and allow the trial to go forward, just so that the American people in November know one way or another the truth, and let a jury decide. And I think that is what should happen. But this is a non-frivolous, substantive motion that everybody should know about, think about, and stay informed about, because it has wide-ranging implications and is really the most substantive motion he has made so far in any of his cases. And, like I said, not frivolous. I'm Karen Friedman Agnifilo from Legal AF. Thanks for joining me and my co-host every Wednesday and Saturday.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.